Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors, the place where we not only talk about what's going on in the gun world, our beautiful country, and how we're going to make both of these things fixed. We're going to fix them. That's what we focus on this channel. And what I'm going to show you right now is the assault weapons ban out of Illinois. It might be the one, guys. You saw on Friday the DOJ put an amicus brief in the 7th Circuit saying basically get rid of this thing. And then now you have 35 states' attorneys in Illinois, all from their counties, saying the same thing. The forces of freedom are gathering against tyranny every single day, just like we do on this channel. So if you are down with that mission, make sure you hit that like button, subscribe to the channel, turn the notification bell on, because this is the place for that prescription of freedom, and thank you in advance for checking that out. All right, guys, so as we dive into this, make sure you follow me on X at BradenLOA. We are rapidly approaching 20,000 followers, and we are grinding every single day on that platform. Amazing things coming, so make sure you're over there on X at BradenLOA. And as I pull this up, guys, make sure you go into the full-on preparedness mode for what we're dealing with our nation. We're at 5 months in with all the big protests and the riots and all the outrage and emotional pour out. Make sure you're fully trained and you're fully head on a swivel, and you know not only the firearm you have, how to use it, but also know your legal rights. There's a link in the description box below. USCCA put out some free training localized in your area just for that purpose. There's a lot of stuff going on. The best case scenario you could do is at least know your options. There's a link in the description box below which is isolated to your area, and you can find anything with it you want, any training in that area, all across the United States. Link in the description box below, and thank you guys for checking that out. All right, let's get into this, guys, because before I actually show you, I pulled up the wrong thing here. Before I actually show you that amicus brief, let me jump over here and show you what FPC just posted. FPC Legal Alert. The Department of Justice has filed a brief with the 7th Circuit in support of our win over Illinois' assault weapon. That was on Friday. This is today. 35 states' attorneys have filed an amicus brief in support of our lawsuit challenging Illinois' assault weapons ban. And everything's linked in the description box below. I always bring the receipts, but that's where this is coming from. We've got 35 counties now saying, you know what? It's time, let's push. Now let's get right over to the other document, because I want to show you this amicus brief, because they did a really good job on their state level as well. And it's important to highlight how the pushes even at state level are just as impactful. As you can see, Illinois state attorneys, I'm just going to run through this really quickly because there's a lot of really great things that all these states' attorneys did. Again, I try not to make you sick as I scroll through these things, but it's a long document, to be quite candid. All right, so here is the amici curiae. States' attorneys, like those joining as amici, are enjoined by their sworn duty to protect and defend the rights of citizens residing in their respective counties. They each swear the following oath. I do solemnly swear that I will support the Constitution of the United States and the Constitution of the State of Illinois, and that I will faithfully discharge the duties of office of State's Attorney according to the best of my ability. United States, that'd be the Bill of Rights, and Illinois, all right? However, on its face, the act violates the Second Amendment to the United States Constitution, which protects an individual's rights to bear arms and is therefore unconstitutional. Now, they're talking about the PICA, or the assault weapons ban that Illinois passed, okay? That's the entire point here. Summary of argument, because there's a lot of really good draws they make. The DOJ one was damn near perfect. This one is really good, all right? The Second Amendment to the United States Constitution, a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Through the 14th Amendment, this right is fully applicable to the states. This is where they start putting out the reasons of why their belief is this strong, and it's really good. Common use for self-defense today, a sweeping ban on an entire class of such arms, is categorically unconstitutional. It is absolutely correct. They cite the Heller decision. Since the act is a flat ban on a large class of arms, including essential components of firearms, widely used for self-defense today, the act is unconstitutional under Heller. They're going to go down the list of where this is unconstitutional. Bruin, Heller, McDonald. Guys, the tapestry of freedom that we have been building over the last 10, 15 years is really starting to come into sight. Thus, in Bruin, the court found that, quote, post-Civil War discussions of the right to keep and bear arms, which took place 75 years after the ratification of the Second Amendment, do not provide as much insight into its original meaning as earlier sources. That's the point, guys. They are trying to do this game, and you saw this with the Attorney General of New Jersey, Platkin. Well, there's debates of when's actually, historical context. Of, it could have been like Reconstruction, or it could have been the ratification. It could have been 2010. I mean, like literally, it's a big joke. They're trying to get around the Bruen decision by just making stuff up. All right. The constitutional conclusion, supported by the historical record, is inescapable. The act violates the Second Amendment and cannot stand. Let's keep on going because it gets even better. The act, as a ban on a class of arms in common use for self-defense today, is categorically unconstitutional under Heller. Just as the First Amendment protects modern forms of communication and the Fourth Amendment applies to modern searches, the Second Amendment extends to arms that did not exist at the founding. That's a Bruen underlining. See also Catano versus Massachusetts. This one is important. It invalidated the state of Massachusetts ban on stun guns, and that only took, I think the number was like 200,000. That was common use. Yeah, there's 25 million AR-15s in the United States. All instruments that constitute bearable arms, even those that were not in existence at the time of the founding, come within the ambit of the Second Amendment. Guys, I guess the best way to say this is the proponents of freedom, even in deep blue bastion states like Illinois, are becoming emboldened because the DOJ is supporting them, because the Bruen decision exists, because the Loper Enterprises case exists, the Cargill decision exists, the Heller decision exists, the McDonald decision exists. We have enough at this point where we can bring forward a very well-sourced argument. That's the entire point, but let's continue. Statistically, the weapons and magazines banned by the Act are in common use. They are in common use. That is irrefutable. It is no doubt at all that they are in common use. Neither semi-automatic weapons nor the 10-plus capacity magazines are dangerous and unusual. That's a stab directly at the Act because that's why they tried to ban them, because they're dangerous or unusual, and they're not common. That was their whole point. But this is the thing, guys. All of the individual pieces that we have are all tied together in a very, very well-sourced document to defeat this crap. The Act is inconsistent with the historical tradition of firearm regulation and is therefore unconstitutional under Bruen. Again, this is all from the state-level attorneys, okay? This is on top of the DOJ-level attorneys, of which the amicus is sent to the exact same case in the exact same court. They're telling the Seventh Circuit to, hey, stand by this and strike this down. While this debate will undoubtedly endure, at least this much has been settled since 1791. The Second Amendment, quote, the very product of an interest balancing by the founding generation which ratified it, elevates above all other interests the right of the law-abiding, responsible citizens to use arms for self-defense. Guys, these things are gold. And wrapping up, wherefore, amici pray that this honorable court affirm the district court's holding and find the Act unconstitutional under the Second Amendment and thereby secure the constitutionally protected rights of law-abiding, responsible citizens in the counties represented by amici and throughout Illinois. Dated June 13, 2025. Guys, I'm going to go big on this real quick. What we're dealing with right now and what we're looking at is the DOJ coming down and saying, hey, Seventh Circuit, affirm the idea that the bans on ARs and magazines is unconstitutional. The state-level attorneys are coming in and saying, hey, yeah, no, we completely agree. Since we're in the state, we also would like you to do that. The gun-controlling forces are going to do the same thing. Every Time for Gun Safety, givers.org, they're all going to do the same thing. But the bottom line is, Kavanaugh said in his most recent denial of the Snopes case, we expect a case in 1 to 2 years. This one is already at the Seventh Circuit level, the Court of Appeals, and you're getting all these amicus briefs that are coming forward telling them to affirm it. And when they affirm it, the gun controllers will 100% attempt to send it to the SCOTUS. They will appeal it. And when you're looking at that, that's the case right there. And this one is a pretty solid one. I will keep you updated on this, guys. Let me know what you think in the comments below. Is it nice to see some people actually showing a pair of pelotes? And I will see you on the next one. I'm Braden. Later.